organization that not only helps with our law enforcement activities, but also strives to protect our property rights. In fact, it's in our name, the South Texans Property Rights Association. This legislative session, STPRA, along with a number of other landowner groups, pro-landowner groups, Texas Farm Bureau, Texas and Southwestern Cattle Raisers Association, Wildlife Association, you might recognize some of those names. About 30 different groups are together focusing on a group called Texans for Property Rights. And we have some legislation that we are trying to get passed to reform our eminent domain laws in Texas. What is eminent domain? Eminent domain is the power of the government to take your property for public use. But the Fifth Amendment to the United States Constitution says you have to give just compensation when you take that property. What a lot of people don't know is that in Texas, not only can the government take your property under eminent domain, but also oil and gas companies, pipeline companies, power companies who want to put power lines across your property. Texas Department of Transportation, but also toll road companies. Now, hopefully a lot of that has kind of died down in the last couple of years. But we have a need to pass some common sense reforms to our eminent domain laws. And I have a handout here that should be passed around. If y'all have some more, get them around to the people in the back. That lists some bills that the Texans for Property Rights Coalition, which includes STPRA, is trying to get passed this legislative session. The keystone bill is Senate Bill 740, and that bill is sponsored by Lois Cohorst, who's the state senator for the District 18, which runs from Houston all the way down to Corpus Christi. It was in Senate State Affairs this last week. I testified on behalf of STPRA in support of the bill, and I won't name names since we're being recorded, but, you know, we had a big group of organizations, cities, counties, oil and gas associations, who are testifying against our common sense reforms for eminent domain. Let me talk a little bit about what the bill does so that you can be a little bit more informed about what we're trying to get done. First of all, we would like to see landowners be able to be reimbursed for their own expenses in defending against a taking, an eminent domain taking. This makes sense that a lot of times it's a death by 1,000 cuts, whether you're a small landowner or a large landowner that has a lot of different pipelines going across their property. On our ranch, we have over 20 different pipelines and power lines that have crisscrossed our property over the last 20, 30, 40 years. Some of them are in the corner of a piece of property. It isn't worth it for us to go to court to try and contest the taking because the fair market value of a little, 100-foot section is not going to be enough to justify doing that. But that isn't a reason for these entities to make lowball offers. A lot of times what they'll do is they'll say, well, we'll give you $1,000 for this easement across your property. Well, that property is devalued potentially tens of thousands of dollars because of that power line or that pipeline going across the property. But because the cost of going to court is so much, to hire an attorney for $15,000, $20,000, $30,000 to fight against the government, you're in a lose-lose situation. Even if you win, you're still out of more money trying to fight the man than you are if you were just taking their lowball offer. So we want to level the playing field. We also want to require a bond for appeal. A lot of these entities then, even if you win, they'll appeal it to district court or to the courts of appeal, all the way up to the Texas Supreme Court. While they hold your property and you're out of your property, your independence of appeal. Even if you win, you don't have your property for 5, 10, 15 years. Make sure that they're able to post a bond that you can recover against if make sure that the deeds and the easement documents that they give to landowners, especially because many of them are not represented by attorneys, that they contain common sense property rights protections, such as terms that we negotiate when we have an attorney, such as keeping fences locked, keeping gates locked, not tearing down fences, not being responsible for injuries that occur by workers when they're on your property that's being taken by eminent domain. You know, a lot of times you could be liable for someone else's injury on property that isn't really yours anymore because of a pipeline or power line construction. Simple, basic things like that need to be in the documents that they offer to landowners, since most people will just sign whatever's put in front of them. You know, they send out landmen who, you know, say, you have to sign this, and, you know, whether it be little old ladies or young men who are managing their family's farming and ranching operations, they sign it because, hey, they don't know any better to negotiate these types of easements and deeds. So we need to make sure that the statute sets forth some basic property rights protections. We also want disclosure of appraisals. A lot of times they will give you, they're supposed to give you an appraisal if they give you an offer. But then if you contest it and you go before your special commissioners in your county to set the valuation, right before the hearing they will bring a new appraisal and kind of ambush you. Make sure that anything that they present before the special commissioner's report is disclosed to you in enough time for you to be able to prepare your own appraisal and be able to fight fair for the fair market value of your property and protect your constitutional rights. And then the last thing is property taxes. A lot of times property is being taken, but it's still titled in your name. As a result, you're still paying property taxes throughout the pendency of these sorts of proceedings for years and years, where you might not have access or full use of that property. We need to make sure if the government or another entity that has the power of eminent domain is taking your property, that you are not responsible for continuing to pay property taxes on property that won't be yours at the end of that proceeding. So those are all very common sense reforms to make sure that level playing field is had between landowners and the governmental entity, and in many cases private entities that are taking property in eminent domain. The bill has not been voted out of committee, and in fact, when we went to testify, again, I'm not going to name names, but we had a former statewide elected official who was pro-landowner when the elected official was in office, but is now a paid lobbyist for the oil and gas companies, who was testifying about how bad these common sense protections trying to level the playing field are for this state. 20 groups, whether it be governmental entities, Association of Urban Counties, all the way down to the Texas Oil and Gas Association, were testifying against the bill, where us little landowner groups are sitting here trying to get these common sense protections. Call Senator Huffman. She's the chair of the State Affairs Committee. She is working to try and get this bill out of committee. Let her know that you support it. I put the phone number there. Also, Senators Lucio and Zaffarini, who represent South Texas, are also on the committee. Ask them to vote for this bill because this is a keystone of our efforts. In the Senate, there are a couple of other bills that have parts of these reforms. I've listed them here. They're being held to see if this bill will make it out. If it doesn't, we'll try the other bills. In the House, Abel Herrero out of Corpus Christi is the chair of the Land and Resource Management Committee. These same reforms are in the separate bills I have listed here. House Bill 2684, House Bill 2694, and House Bill 3441. They contain the same reforms that are in Senator Colcourt's bill, but are in separate bills because it's going to be hard to get them passed in the House. The House has a lot more influence from municipalities, associations of counties, and a quarter of the House represents Harris County. That tells you something. This is an urban state, and so it's very important that the rural voices are heard over in the House, especially since Representative Herrera is from South Texas. Reach out to his office to make sure that those bills are not only given a hearing, but are also voted out of committee. 14 and Senate Joint Resolution 51 by Senator Estes has not yet been heard in Senate Finance. What it would do is stop these appraisal districts that are taking your agricultural use exemption, your open space exemption, your wildlife exemption, and taking it away from you because you happen to have an oil and gas pad on your property or a pipeline junction on your property. They are saying this is a change in use, and in fact, it's still agricultural property. And because it's a change in use, they're allowed to assess a penalty of the difference in value between agricultural use and the development value of the property for the last 5 years, all at one time. That penalty was put into law to prevent developers from buying land in an urban area, say an urban county, putting a couple of cows on it and claiming it agricultural use and then building a hotel on that property. But it's being used by appraisal districts in LaSalle County and Frio County, and it's working its way down here as well as a way to generate more revenue for some of these counties and other taxing entities. This bill would clarify that if you are still maintaining title to this property, if the land goes into the oil and gas company's title, say you sell it for a substation or something like that, then it makes sense that it's a change in use. But if you have a pad that is 10 acres and once the drilling is over with, it goes down to 2 acres, there is no real change in use occurring. You're going to use that land for agricultural purposes once this temporary activity is over with. This bill would make sure that you don't pay a penalty for having oil and gas development on your property, especially if you don't own the mineral rights. If you would just own the surface, you're getting penalized for revenue you're not even seeing. So that's an important bill. Senator Hinojosa, Chuy Hinojosa, is vice chair of that committee. Please call him to try and get this bill heard in committee. Last thing I want to talk about relates to what our last speaker talked about, landowner compensation. This has been something that STPRA since 2009 has continually broadened our efforts to get compensated for the impacts of law enforcement on our property. House Bill 2306 by Ryan Keane was heard this last week in Homeland Security in the House. It would allow our sheriff's departments and our local law enforcement departments that sell abandoned motor vehicles from bailouts to use those monies to help repair fences and help fix some of the problems that have been caused by the bailouts in the first place. Right now, they can't use the proceeds from the sale of these vehicles. I know Kirby Brumby, a friend of mine, he's a sheriff over in Goliad County. They sell 30 vehicles a month. So 1 vehicle a day that they pick up off of 183. So there's a lot of money that's there that can be used to help compensate landowners for the damage that's being caused by bailouts that happen on their property. This bill would allow that to happen. Representative King is chair of that committee. It's been heard. Call him and ask him to vote that bill out of committee so we can get it on the process and allows landowners to be compensated for some of the damage that occurs on their property. I have my number here. Robert Howard, who is a consultant to STPRA, helps us with lobbying in Austin. I'm a volunteer.